We often get questions about when it's possible to sue for breach of contract in Oklahoma. Contracts form the backbone of many business and personal relationships. So when one party fails to honor their side of a deal, the other may suffer financial harm or disruption. In such cases, the injured party may have grounds to sue for breach of contract. But not every broken promise gives rise to a valid legal claim. A breach of contract occurs when one party fails to perform a duty or obligation outlined in a valid agreement. This failure may involve not doing what was promised, doing it late, or not doing it to the agreed standard. In Oklahoma, to succeed in a breach of contract lawsuit, the plaintiff must show that a valid contract existed. The plaintiff performed their part or had a valid reason not to. The defendant failed to perform as promised. The plaintiff suffered damages as a result. Not all breaches are the same. In Oklahoma, a party may sue for breach when the failure is material, a serious violation that goes to the heart of the contract. For example, if a contractor completely fails to perform the agreed work, that may justify a lawsuit. Anticipatory, when one party makes it clear they will not fulfill their obligations before the deadline. In that case, the other party doesn't have to wait for the actual breach to occur and may sue right away. Partial or minor. Sometimes, even small breaches can cause measurable harm. While these may not always justify ending the contract, they can support a claim for damages. You can sue for breach of contract in Oklahoma when the other party fails to meet a clear and essential term of the agreement. You upheld your end of the deal or had a valid reason not to. You suffered financial losses or other measurable harm as a result. The breach was not excused or legally justified, such as due to impossibility or mutual agreement to terminate. For example, if a contractor builds a substandard home, you may be able to pursue a lawsuit. Oklahoma law imposes a statute of limitations on breach of contract claims. You typically have 5 years to sue on a written contract and 3 years to sue on an oral contract. Failing to file within these time frames may bar your right to recover.